Listen.
Thank you, Mr. Chairman, and congratulations
Yeah.
to all of you.
Place it in the start.
Come
on.
Judge on the far end. Tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Okay. Do you know what purposivism is?
In my 12 years as an assistant attorney general and my 9 years serving as a judge, I was not faced with that precise question. We are the highest trial court in Washington state, so I'm frequently faced with issues that I'm not familiar with, and I thoroughly review the law, research, and apply the law to the facts presented to me.
Well, you're going to be faced with it if you're confirmed. I can assure you of that. Mr. Berkman, define originalism for me.
Thank you, Senator, for that question. My understanding of originalism.
I'm going to turn your microphone on.
Thank you, Senator, for that question. My understanding of originalism is the notion that the Constitution has an enduring and a fixed nature, an enduring quality and a fixed nature to it.
What does that mean?
It means that the words matter, and that the words that the framers used to draft the Constitution matter, and that it has a fixed quality to it and has an enduring nature.
Well, how do you determine the fixed quality? Who determines what the words mean from whose perspective?
Senator, in my time as a magistrate judge, I've not dealt with issues of constitutional interpretation, but my understanding is that you would begin with the language of the Constitution itself.
Yeah, okay, I agree with that. All right, anybody want to add? Counselor, Ms. Merchant? I mean, here's what I'm getting at. When you say originalism, the words mean what they mean. From whose perspective?
Thank you for the question, Senator. Similar to my colleagues, I would look to the text in terms of originalism. When you're asking, to the extent that you're asking what I would look to, if so fortunate to be confirmed as a judge, I would look to the precedent, first of the text.
Yes, ma'am, but I'm trying to get you to define originalism for me. What's your understanding of it?
Yes, thank you, Senator. To clarify, my understanding of originalism is similar to that of my colleagues. And in looking at the text and the meaning that was intended in that text, that is the spirit of...
Intended by whom?
By the original writers of that text.
So to you, originalism, you try to interpret what the writers, the authors meant?
In an analysis, a constitutional analysis, it would be the originalism, the text, and the intent of those that drafted the Constitution.
I don't think that's accurate. Does anybody disagree with that? When the Supreme Court says it's following an originalist approach, and in a number of cases, all particularly dealing with Second Amendment, the U.S. Supreme Court has said, on this one, we're all originalists. I think it was Judge Sotomayor who said that, Justice Sotomayor. And on many areas, she's more of a proposivist, but on that she was an originalist. She didn't say we're looking for the meaning that the drafters intended, was she? Anybody want to add to that?
Senator, I'm happy to add to that. My understanding is that...
That's okay. Let me just ask one more. I'm about to run out of time.
I love this guy.
Judge,
I love this guy.
on the far end. Can you tell me what the independent state legislature theory is? I'm just asking you, not your opinion of what is it? It's before the Supreme Court now.
In my 12 years as a Washington State Assistant Attorney General, and
Right.
that particular doctrine was not presented to me.
I'm out of time. Thanks, Mr. Chairman. Dan, what I'll refer to as the St. Paul's case, the civil litigation.
She's supposed to.
In the civil litigation, what did the plaintiffs allege?
The plaintiffs allege, Senator, that the school failed to protect Miss Prout from being raped by Owen Labrie.
Right.
The claims were in negligence and breach of fiduciary duty and Title IX.
And what were the plaintiffs asking for in damages?
They were asking for civil damages in the form of monetary relief, Senator.
How much?
Senator, I can't recall specifically if there was a request made at the onset of the case, and I certainly can't speak to the aspects of the case that involve a confidential settlement.
I'm not asking you about the settlement. I'm asking you about the allegations. Were they in the hundreds of thousands, millions?
I don't recall, Senator, and I don't believe that they necessarily would have had to specify that in the complaint when they filed it.
All right. You were in state or federal court?
This was in federal court in the District of New Hampshire, Senator.
Okay. And at some point, you filed a motion with respect to the naming of the minor. Is that right?
That's correct, Senator.
Tell me about that motion.
The family of the minor.
But tell me about the motion first.
So they filed the motion seeking the protection to proceed anonymously.
Oh, so it was their motion.
That's
Okay.
correct. We had the school had an opportunity through its counsel to respond to that motion, and the school agreed to allow the family to proceed anonymously at all pretrial phases of the case, and asked the judge as a condition of that to require the lawyers to try the case in a court of law and not in the media. We, as the lawyers approached the case, the school's perspective was that the request for the lawyers to try the case in the court of law as opposed to the media was fully compatible with the family's request to proceed anonymously and with privacy.
Okay, so I'm just trying to understand. So the plaintiffs filed in the name of Jane Doe. And then the plaintiffs filed a motion. You didn't file a motion. The plaintiffs filed a motion to continue ask to continue anonymously. Is that right?
That is correct, Senator.
And then the position of the school, you went to your client, St. Paul's, and said, how do you want to respond? And St. Paul's says, we'll agree to that so long as the plaintiff's lawyers don't try this case in the media. Is that correct?
The position the school took was that they would agree to that provided that the lawyers didn't try the case in the media.
Okay. Was that your position or was it your client's position?
That was the school's position, Senator. I was just an advocate advocating for my client as I had a duty to do.
Okay. So that's what your client told you to file this response. You did. I'm assuming that St. Paul's School was getting the hell kicked out of it in the media. I'm not saying justifiably or not. I'm just stating that as a factual matter. And then what happened?
The judge never got to hear the motion that was filed, Senator, because the family that had filed the lawsuit elected to withdraw the motion before the judge could consider it.
And what was the effect of that?
The effect of that was that the motion that was filed became moot and the judge didn't need to address it and never addressed it. What I can say...
And so the plaintiff continued anonymously?
No, at that point, the family elected to proceed without using pseudonyms, Senator.
So the controversy then is about a motion that the plaintiffs filed that you responded to on behalf of your client, and the motion was never resolved, and the plaintiffs then decided to use real names. Is that right?
I believe that's correct, Senator. Again, my role in the case was as an advocate, advancing.
I get it. That's what I'm getting at. I mean, your job's to protect your client.
I had a duty as an officer of the court to advance my client's interests to the best of my ability, Senator.
What if you'd gone to your client? I'm way over. I'm sorry, Mr. Chairman, but it'll be my last one. If you'd gone to your client and said, look, well, strike that. I think I understand what happened. Thank you, counsel.
Senator Lee. Senator Blackburn.
Thank you, Mr. Chairman. Mr. Delaney, I want to stay right there with that same
View.